Hello, everyone, and welcome to our final AbleCon session, an overview of guardianship and the alternatives. We're honored to be joined by Catherine Davey, principal and founder of Davey Law Group. For nearly 30 years, Catherine has practiced law. She is based in Orlando, and since 2001, she has had her own firm and focuses her practice in the areas of probate, guardianship, guardian advocacy, estate planning, and the drafting and implementation of special needs trusts for those with physical and developmental disabilities. She also serves as the administrator for her daughter's Able account and says that when her youngest daughter was born with Down syndrome, her purpose in life became abundantly clear: to change the lives of those she serves, to build a better future for her daughter and the entire community. It's wonderful. Catherine, welcome. And
Hi,
please
guys.
take it away with your presentation.
All right. So if you will start my PowerPoint, then I will talk you guys through it. All right. So I always start with a little bit about me and why I'm here, because what I always say is 10 years ago, I was a good lawyer. I'd been doing this a long time. It was important to me. It was good work. But 9.5 years ago, that little nugget was born and she changed my life all for the best. And so now I am the most zealous advocate for people with intellectual and developmental disabilities, and making sure that what you hear about this topic is education-based and not fear-based, because I hear way too much fear in this community about these issues. And it's critical to me that you guys have good and accurate information to rely on. All right. There's my 3 daughters. You will hear me make fun of them frequently throughout this process. And I promise you, I have made fun of them just about these things in front of them as well. They know it's coming. And even if they watch this recorded video, they'll be like, that's what mom does. So we are going to talk about alternatives to guardianship, included supported decision-making, substituted decision-making, guardian advocacy, guardianship, as well as the next steps. And are there other things that I need to know? And then we're going to give you a whole bunch of resources that you can go back to and rely on and read further, so that that will give you some peace of mind in the future. Okay? All right. So we start with the basics. Why do you have to do anything? Well, up to the point of 18, everyone is presumed incapacitated. By operation of law, my 17-year-old, although she is completely convinced she is fully cooked and understands everything and is completely independent, I promise you she still has a lot to learn. So that's how the law works. Until they're 18, they're not competent to make decisions for themselves. At 18, regardless of an intellectual or developmental disability, or if they're a completely typical person, they are presumed to be fully competent, okay, in the eyes of the law. So what are some of the fears that I've heard over the years from parents about this whole process? That the minute their kiddo turns 18, that they won't be able to make medical decisions for them or consent to treatment for them, that they may be exploited or taken advantage of in some way financially, that no one will let me help them, or no one will help them or let me help them, and that I can no longer advocate for my kiddo or protect them, and I can no longer advocate for them at school. The other thing I do as I give this presentation is I talk about it very personally. So you'll hear me refer to May, my own daughter, over and over again. I think that helps you understand, because it's very personal for all of us. So when you hear me refer to May, just think of your own kiddo in that place. All right. So the answer to every fear is not the legal system. There are lots of things you can do yourself on your own. So if you're concerned that your kiddo, or in my case, May might be taken advantage of financially in some way, I can go freeze her credit. I've given you the website. There's a whole process. It's pretty straightforward. And I can just freeze May's credit. That way someone can't convince May to go get a credit card and give it to them and ruin her credit, okay? Or take advantage of her financially. If I'm concerned the doctors won't talk to me about May or discuss her treatment with me, depending on if May is capable of signing it, she could sign a release of information. She could sign a HIPAA form and allow me to be part of that conversation. Now, my kiddo's 9, so we're a long way from deciding that, but we'll get there, right? And we're going to talk you through how you're going to make those decisions for your kiddos as well. That there would be no one to act on May's behalf if I'm not there and if I'm not allowed to be involved. Well, what I always say is don't forget your own estate plan, right? You put the oxygen mask on yourself first, so don't forget to do your own planning. I have a case right now that's very sad where mama did not do planning for her child who's now in his 40s. And when she passed away, she left a bit of a mess because there was no clear plan over who was supposed to help, what was supposed to be done. And she was just paralyzed, and she was paralyzed with fear. So she did nothing. And so now we're in a little bit of a jam trying to fix things. So that's another reason I'm here, right? I want you guys to be so confident and so comfortable that you're like, I know what to do. I should do this. Okay. All right. That maybe your kiddo has behaviors and you're afraid that you won't be able to protect your child, right? We've had those cases. We have those cases. Maybe you have a kiddo who likes to make phone calls that scares people. Don't forget that you can register, at least in Central Florida, with the Orange County Sheriff's Department. There are registries now all over the state of Florida through your local law enforcement. There are bracelets we have our kiddos wear, even if they have diabetes. If there's anything, right, there's bracelets they can wear. There can be a seatbelt tag, and there can even be a tag on their shoe. So lots of ways to address the fact that our kiddos might not react typically in an emergency situation or might make bad decisions that really have no malintent. It's part of who they are. If you're concerned that maybe teachers or educators as part of the IEP or transition process won't speak to you, there are education proxies that are in progress that are being considered by the Florida legislature, but there are definitely education documents that if your kiddo has that ability, they could sign. Okay. All right, next slide. Okay, so I always like a good graphic so you have a really strong mental image of how the process works. And so I like the Florida Developmental Disability Council's triangle that shows you at the very bottom, the least thing we can do is supported decision-making. I'll explain what that is in a minute, but it goes all the way up to the most restrictive thing we can do, and that's guardianship. Okay, lots of stuff in between, but those are the options. All right, so supported decision-making. All right, so I want you to think about when you turned maybe 16 or 18 and you went with mom and dad to the car lot. Maybe it was a used car lot if you were like my family, and you picked out a car, and maybe your dad looked over the car and your mom read the contract, or in my family, right? I'd be the one to read the contract. That, there was a whole team. Maybe your uncle came to help your dad. Maybe there were other people, all sorts of people involved in helping you make the very best possible decision about buying that first car. Okay, that's functionally what supported decision-making is. It's a whole group of people helping May that would be called trusted advisors, such as friends or family members or other professionals to help her that would assist her or support her in decision-making. And they can be delineated by type. There can be a financial trusted advisor versus a health advisor. All those things are options. At this time, it is not the law in the state of Florida. That law is not passed, but it is being considered every year. Every time the legislature meets, they discuss it again. So it is a great idea. I am not saying that because it is not the law, it won't work. I'm just saying that it's not the law. So if it fails, you could have some problems. Okay. So it works until it doesn't, and then we move on. All right. So another cute picture of my kid that really has nothing to do with substituted decision-making, but she's stinking cute. So there you go. Substituted decision-making in its most basic essence is documents. right? So I've decided that Facey is going to be my durable power of attorney. So I've signed a document that says if somebody needs to make financial decisions for me and I can't, that Facey's going to do it. Okay, there she is. She's going to do it because I've signed the document. So there's a list of instructions in that document, and it tells her exactly what to do and exactly what powers she has. She is literally substituted for me. And that would be, I'm on a trip around the world doing something fabulous, or maybe I'm sick and in the hospital, and I need someone to make those decisions for me. So that's how that would work. It's a document that I've signed. Typically, it's signed in the presence of witnesses and a notary, and it's very clear what powers Facey has. What I want you to understand, excuse me, is the bar for this is not as high as you might think. So you might say, well, May has Down syndrome. How could she possibly sign a power of attorney? Well, she has to be competent, right? Competent in the eyes of the law. But that's why I included this language from the consumer pamphlet from the Florida bar, is that she has to understand the power of attorney document at the time it's signed. She has to understand what it can do, right? That mommy can still make decisions for her, to whom it's being given, me, mom, and what property would be affected by that power of attorney, right? So whatever it is she has, I could manage with that power of attorney, and that I'm the one who would make those decisions for her. That's not necessarily a giant hill to overcome. You know, if your kiddo can understand that, if May can understand that when she's 18, honestly, not a bad choice. Okay. So, but also the other piece I want you to understand is, just like in regular estate planning, as long as May can make her own decisions, she can, and she does. This does not give me the ability to take away decision-making from her. Rather, she's making decisions and I do it only when she can't. Okay. So if May is making bad decisions, like some 18-year-olds do, this won't stop me from letting her make those bad decisions. That's something else. And we got to keep going up that triangle of more restrictive alternatives. Okay. All right. So that one was finances. This is healthcare. So I want you to imagine May is 18. And if your kiddos had the medical experience my kiddo has, I'm confident that given the right to make medical decisions, she will pass on a number of things because she hasn't really loved the doctors during her childhood, because that's just the nature sometimes of having illness or a syndrome that comes with a lot of medical stuff. So, but a healthcare surrogate is who would make medical decisions for you if you can't. Again, you're sick, you're in the hospital, the doctor comes running out and says, I have to take out her spleen. Who's going to make that decision for her? And then you've chosen someone who would make medical decisions for you if you can't. Again, if May is able to sign that document, if she's able to understand that, including that she has the right to choose and refuse medical treatment, she could sign a power of attorney when she's 18. She can't sign it now, right? Because she's only 9, but she could sign it if she's 18 and she could understand those things. All right. If guardian advocacy is the best choice, then like we did for this family, we can go to court and we can have a guardian advocate appointed for your loved one. All right. So really conceptually, before you get to the idea of guardianship, because remember, that's at the top of our pile or top of our triangle, guardian advocacy is a streamlined legal process where the court removes only certain rights from a person with an intellectual or developmental disability and appoints a guardian advocate to make specific decisions based on the rights removed for that person. Okay. So let's just say that's what's the appropriate choice when May turns 18. Then we would file various documents with the court, and the court will then have oversight and control. And I just really want you to think in terms of oversight. It's less about control and more about oversight of the person with an intellectual or developmental disability until the rights removed could be restored to that person. And there is absolutely a process to restore rights to people, right? I always describe it like if there's a person in a car accident and they're in a coma, there may be a guardianship for them, but when they wake up from the coma, then we restore rights to them. And that happens in guardian advocacy as well. Okay, next slide. All right. So the basis for a disability, and you've heard me say it once, but I like to repeat things, just like I talk about the least restrictive alternatives over and over again, is the basis for a disability for a guardian advocacy is an intellectual or developmental disability. It's not a car accident. It's not Alzheimer's. It's not something else. It's just an intellectual or developmental disability. It can be of the physical person, right? Who can make medical decisions for me, things like that. And it can also be over property, which is money, and it can also be real estate. What rights can be taken away? In a guardian advocacy, the law is very clear that only some, but not all rights can be taken away. Now, I will tell you, judges frequently overlook that. So if you say to me, my kiddo can't exercise any of these rights, now I have to do a guardianship, I will tell you most judges will still let you do a guardian advocacy, even though your kiddo may not be able to do any of those rights or manage them themselves. Okay, is an attorney required to do a guardian advocacy? And the answer for all lawyers to everything is it depends. If the person has property, if they have money, then the guardian has to have an attorney. If the person, if May doesn't have money and I'm seeking guardian advocacy of her person only, then she doesn't, then I as her parent don't have to be represented by an attorney. One of the documents you will have to file with the court is a letter from her treating physician, like her pediatrician, that says that May has a developmental disability that manifested prior to the age of 18, right? She was born with Down syndrome, so clearly she did, that she's unable to handle her own personal matters related to finances and physical well-being, and that she needs the assistance of a guardian advocate to meet the essential requirements for her physical health and safety, right? So we've literally prepared a form that you'll use and will give you access to all those things so that you can do this yourself, but you're going to have the pediatrician sign that letter from the treating physician so that they can say that, so that it says that and the court understands that. Okay. Okay. I understand that this list from chapter 393 of these 6, we'll call them syndromes, is not a master list, right? 1,000 years ago when I was in high school, the only one honestly I had ever heard of was Down syndrome. They've given us 6. There are many, many, many more. What we typically do is we include others such as Angelman's and some of the others that are very common into intellectual disability. Okay, so don't worry if you don't see whatever issues your child has, or maybe it doesn't even have a name. It's just developmental disability. That's okay. We'll include it and you'll be fine. And you can still do a guardian advocacy because we'll lump it into intellectual disability. Okay, no problem. Okay, I've given you the statutes mostly as a resource so that you can go back and look at them later. We don't need to spend a bunch of time on this slide. But this one is the one where this is the some but not all that I wanted you to see, that it comes directly out of the statute. And I also want you to see the part where it says there is without an adjudication of incapacity that a guardian advocate can be appointed. Okay, so there's no determination that May is incompetent or incapacitated. It's just we have the letter from the treating physician, and then we go right to what rights can be taken away from her or what decision making is taken away from her. And again, this is where the some but not all comes from. Okay. Advanced directives, I wanted you to see it literally from the statute. So if someone says to you, your child has Down syndrome, they can't have a power of attorney because they have Down syndrome. You can say, I know that's not true. Here it is in the statutes. They absolutely can. And if they can, and if they have, then you don't need to go on to guardian advocacy. And honestly, the court won't go on if they have a validly executed power of attorney or healthcare surrogate. They will not. The laws are very clear. And it says a guardian advocate may not be appointed if the court finds that the advance directive provides an alternative, right? So least restrictive alternative. We have to do the least we can to help May get by in life. Okay. All right. All right. I broke the rights down this very specific way because these are the 12 rights that can be taken away from an individual in whether it's a guardian advocacy or a guardianship. Okay. They're broken down into delegable and non-delegable. Delegable is something that somebody else can do. Non-delegable is things that no one else can do for you. You can't marry for me. You can't vote for me. You can't have a driver's license for me. So that's why they're non-delegable. And we can talk through them briefly. So I've talked to you through some of those, but the right to travel, the right to seek or retain employment, the right to contract. Some of these are property, and those come up sometimes, right? Where we have cases or lawsuits tied to our kiddos where we have to jump in and help them. To manage property or make gifts, to determine their residence, to consent to medical and mental health treatment. Those are all physical person ones, right? We've now progressed to that. And to make decisions about social environment or other social aspects of life. Now, I will tell you, when I first started doing this, I was quick to listen to my clients and help take the social decisions away from them. But I've now learned a little better, because how do you have a job if you can't make social decisions? How do you go to school? How do you pursue an education if you're not allowed to make social decisions for yourself? You can't. You just can't. So as much as we want to protect our kiddos, whether they're typical or not, you can't keep them in a bubble, and we've got to do the best we can and give them what a dear friend of mine called the dignity of risk, right? She's got to be able to learn and stumble and fall and stub her toe, and we move on. Okay. All right. So in this graphic, I wanted you to see person, right? Those physical person rights versus property, which is money. And that's how we break it down. Okay. Again, you can refer to this whenever you want, and you've got all the information. Each county, each circuit does things slightly differently. I wish I could tell you that although the laws of Florida are clearly written in the statutes, that every court does it the same. That is not true. Every judge, every group has their own special perspectives on what they think works and what they think doesn't work. In the kind of central Florida area, especially in Orange County and Seminole, we take away these specific rights. These are the ones that are removed in a guardian advocacy. To apply for government benefits, right? That's typically something mom and dad are going to do. Once their loved one May turns 18, I'm going to apply for SSI for her. The right to determine her residency and consent to residential placement. To consent to medical and mental health treatment. Now, I make fun of my kiddo, but like I said, she's had lots of sometimes not terrific experiences with medical providers. So I think if she were 18 and somebody said, oh, it's time for the next blood draw, she'd be like, nope, it's just not going to happen. So that may be something I may have to continue to help her with. Here's the social decisions one, right? We really got to think about this. It's not uncommon for us to take this one away, but I will tell you, if they're going to go off to college, oftentimes we will have to go back to court and get this right restored for them. So think long and hard about whether this is appropriate to take that away from your loved one. And then we added in to make decisions regarding education and educational and vocational rehabilitation entitlements. It's not really one of the classic 12 that's in the prior lists, but it's incredibly helpful and incredibly necessary as your kiddo continues oftentimes in the education system until they're 22. And so you need to be able to continue to make those decisions. Okay. Again, I'm going to tell you this changes based on the county. Each county likes it a little differently. So if you're not sure, be sure the judge will tell you what they prefer. Okay. All right. So this is what we all think of as a classic guardianship. Grandpa's gotten older. Grandpa, and you can move forward. may have developed Alzheimer's or some sort of dementia, maybe isn't making the best decisions anymore, and someone needs to step in to protect him. Okay, in a guardianship, generally, there's two cases. There's an incapacity proceeding as well as a guardianship proceeding. The incapacity proceeding is a petition to have someone determined to be incapacitated. Grandpa, I actually had this case, thought the cats were his dead relatives. So one of the signs we had that maybe Grandpa shouldn't be managing his affairs anymore, and that he needed some help. And so the court will then appoint an examining committee as well as an attorney for, in my example, Grandpa. And then they will determine whether the examining committee will meet with Grandpa to determine whether or not he still retains capacity. And they'll file their reports with the court. A guardianship happens, it used to be in the old days, it used to be a separate file folder, right? They'd close the incapacity and they'd move on to the guardianship, because once someone's been determined to be incapacitated, then they're vulnerable and somebody else has to look out for them and protect them. So the guardianship part is a legal proceeding where decision-making authority is delegated to another. Again, in person and property, that's the same. And it continues for the lifetime of the ward, right? That's the title we give to the person who's now in a guardianship, is a ward, or until their rights can be restored, if that's possible, right? Again, think of my example of the person in a coma, right? When they wake up, they can have some of their rights restored. Okay, next. All right. The basis for a guardianship, as opposed to a guardian advocacy, can be anything. It's not just an intellectual or a developmental disability. It could be Alzheimer's, dementia, an auto accident, even minor children sometimes, have guardianships. The types are the same, person or property, and the rights that can be removed in a guardianship are any and all. Right? So it's not like in a guardian advocacy where in theory the person needs to retain at least one right. In a guardianship, all their rights can be taken away. In a guardianship, there is an attorney both for the ward as well as for the attorney. They have to be represented by counsel. That's what the law requires. And requires the court's determination of an incapacity to move forward over that protected person who's now called the ward, right? So that incapacity is going to happen. I give you this slide just because I want you to know there's a giant cost difference between these two things. And there's a big time difference. So that's one of the two biggest differences between guardianship and guardian advocacy. In a guardianship, it typically will take us up to 3 to 5 months to get it established. A guardian advocacy, I've got another slide for this, but you'll see can typically be done in about 30 days. All right, so so when people are talking to you about which do you need, this is a great slide to refer to because you're going to see the big differences between the two different choices, right? You've got the basis, you've got the type, person and property is the same, the rights removed. Remember, in guardian advocacy, in theory, it's some but not all. In attorneys, in a guardian advocacy, mom and dad don't necessarily have to have an attorney, but would, right? Because we're talking about taking away her civil rights. So she would be represented by an attorney, just like in a guardianship, grandpa would be represented by an attorney. So if I'm doing something untoward, that attorney would protect him. Guardian advocacy can be very inexpensive to establish. You can do it yourself. You do not have to be represented by an attorney if there's no property. But guardianships can be incredibly expensive. Incapacity, it's done with a letter from a treating physician. Incapacity in a guardianship has that 3-member examining committee. So there's 3 doctors. And the timing, 30 to 60 days versus 3 to 5 months. Okay. All right. So in the Down syndrome community, we do, October is Down Syndrome Awareness Month. So there's always some bragging rights and there's some fundraisers that happen. So we always dress our kiddos up in cute costumes and try to raise lots of money. So that year obviously was Rosie the Riveter. So, all right. So now I understand the difference between all the choices I have, but how do I know which one to choose? Well, remember, prior to the age of 18, everyone is presumed incompetent. My 17-year-old is absolutely incompetent in the eyes of the law. But over 18, everyone is presumed competent unless the court rules otherwise. So presume competency, but also know that you have to pick the least restrictive alternative that meets the needs of your loved one, right? So how do I know what's right for my kiddo, for my loved one? So we're going to show you briefly the WINGS decision-making toolkit, which you will love and also be slightly frightened by. There's also some other great websites that you can go to that will help you think through this process. But I always remind you as well, don't forget those trusted advisors that you work with all the time. I frequently overestimate and underestimate what May can do. So I love to go back to her teacher, her doctors, the people she sees all the time, maybe her therapists, and have them help me think about and think through what's going to be right for her. Okay. All right. This is the WINGS decision-making toolkit. We're going to give you the link in the PDF as well. It is a fabulous document, and it will make you go through a number of questions to think about with your kiddo. I can decide without the support. I need support to decide. I need someone to just decide this for me. And it's everything from, can I express my own choices and preferences? Yes, my child can certainly express her choices and preferences, and there will be no doubt in your mind what those choices and preferences are. To, can I receive services that provide support? Can I choose my own job and decide what I'd like to do? It really makes you think through all of this. So when a client comes to me and says, I think my child needs a guardian advocacy, one of the things we make them do is complete the WINGS decision-making toolkit, because I want them to be really thoughtful and pause and take the time to answer each and every one of these questions and think through truly what's necessary. And it goes on, as we see on the next page, to some really hard questions that you may not really be excited about answering, including, can May understand that she has the right to consent to sex? I didn't really want to talk about this with my typical 20-year-old, much less, now I'm talking about my 9-year-old, definitely not the same. But when May is 18, will she be able to understand that? Is that something she can manage? I don't know. But this is a thoughtful way to help you get to the point where you feel better educated and better able to make those decisions. Okay. All right. So what are the next steps? Okay. Again, the buddy walk. This year was Captain Marvel, obviously. There you go. All right. So you've got your trusted people helping you. You've done the WINGS decision-making toolkit. You're going to determine what's right for your loved one and your family. If guardianship is best, then you understand that you're going to have to hire an attorney to assist you with this. What I always say is, please do not hire your friend, the real estate attorney, or the guy down the street who does family law. Please hire an attorney who does a huge amount of guardian advocacies or guardianships, because it's critical they really understand the distinction. Okay. In guardianship. If guardian advocacy is best for your family, I always describe it this way. Can I work through the process on my own using the materials available, including the step-by-step guide? I have all of this available on my website, every form you need, every step you have to take, all the way through, including the ORI codes, because you're going to have to go get your fingerprints done. Okay, I've got it all. Can you just do it yourself? Do you really need an attorney? Because remember, if there's no property, you don't have to have one. You can do it yourself. Or do I need an attorney to review my paperwork before submitting it to the courts? This is what I call, do I need someone to look at my homework before I turn it in? Or do I need an attorney to prepare my paperwork and guide me through the process, but I can do the rest? I call that, can I have you do my homework and turn it in for me? Do I, or would I just prefer that an attorney handle the entire process? I've had to learn way too many things during the course of having children, much less children with special needs. Can please someone just do this and do it right for me? You get to decide. none of these, or, whatever the right choice is, depends on you, and you're willing to do all this. I am so proud when I hear families say, I did it myself. I didn't need any help. Great. I'm so happy for you, because that's why we created these forms. That's why we created the step-by-step guide. I want you to be empowered and feel like you have the ability and the choices to do whatever you want within the context of the law as it exists for your loved one. So yay. But if not, if you want help, we're here. I do this every day and I love it. I'm super passionate about it. That's why I do presentations like this one. Okay, but if legal instruments is right, that power of attorney, that healthcare surrogate, then please, again, hire a reputable attorney to prepare the documents. I have attorneys on my websites if you're in Central Florida. If not, consider using the Florida Bar Referral Service. Please, again, do not use a random neighbor who might know something or download a form from the internet. I promise you, those probably aren't as helpful as you think they might be, and you're going to find out at the worst possible time that they didn't do what you thought they were going to do. Okay? If supported decision-making is the right choice for you, there's some information on the website, on these websites. Some of it's through the ACLU and other great organizations that you're going to be able to figure out how to do that and see if that will work for you. Again, the caveat always is it's not the law in the state of Florida, but if it works for you and it works, great. Okay. I wanted to give you just a brief glimpse of what the guardian advocacy on a really practical level looks like. You're like, okay, May needs a guardian advocacy. You're going to petition for appointment, and there'll be some other documents that have to be filed, including an application. That application is, yes, you're literally applying for a job, and that job is to be the guardian advocate for your kiddo. And I've had other people get really frustrated with me. I've had an attorney say, I don't have to complete that. You do, actually. So I'm sorry, and I will too, right? Even though you're the mama, you may still have to complete an application to get this job. You will also have to be fingerprinted. There will be an FDLE criminal background check. And unfortunately, if you are a convicted felon, that is a barring event in the state of Florida to being a guardian advocate. Okay. I've seen judges possibly overlook that, but it really depends. And there are some circuits that absolutely won't overlook it. I would encourage you, if this could be a potential issue for you, I would hire an attorney to help you through this process. There'll also have to be a credit check if there are assets. The court wants to know that you handle money well. If you have bankruptcies or other credit issues, that may be a barring event for you. You'll also have to provide notice to other family members. So if you're divorced, you will have to notice the other parent of your child with special needs. I certainly understand that that can be dramatic and difficult sometimes. That's probably another situation where you're going to want an attorney involved to help you through that process, okay? There will be an attorney appointed to represent May. She will have her own attorney. She will think it's fabulous, more people to pay attention to her. And I promise you, this is not an adversarial relationship at all. The attorneys who have these roles really do understand how this process is supposed to work, and that usually it's just mom and dad continuing to try to make good decisions for their kiddo. So they will definitely represent their client. So if May is adamant, I do not want mom to help me, they will represent that to the court. But we all end up doing what's in the best interest of our client and the best interest of the ward. That's the other benchmark we live by. Typically, there should be a hearing before the court on the petition, and whether or not May attends the hearing will be up to May, and her appearance could be waived. I will tell you, post-COVID, even though there is supposed to be a hearing, there's not always. Sometimes we just get the orders and letters back by email, and that's completely fine, and then there's no hearing at all. So the next thing, and that's getting you appointed, right? There's lots of steps after that. But what I want you to know is just take a breath, because you can change your mind in the future. If May is 18 and needs a guardian advocacy, that could be completely fine. But let's say that by the time she's 21 or 25, that chronological and developmental age have caught up a little bit. And now you go, well, actually, I think she could do that stuff now. we can file what's called a suggestion of restoration of rights and have the court look at whether or not she can have some of those rights restored. That's absolutely a process. I love to tell the story when we did that for a young man who'd had all of his rights taken away, but he'd fallen in love and the family loved her, and it was a great situation. And so we filed the suggestion of restoration of rights, and we had some of his rights restored, including the right to marry. So we have some fabulous pictures of that lovely young couple as they got married. So don't worry that this can't be changed in the future. Okay, it absolutely can. What if I decide I don't want to be guardian advocate anymore? Once the nice person in the black robe makes you something, you can't quit without their permission. So you're going to petition to be discharged in that role, but then we got to make sure there's somebody else to take that job. Okay, so you can, but there's a process for it. The other thing I'm going to strongly encourage you to do is also petition to have a standby guardian advocate appointed at the same time you're appointed. As I always like to describe it, there is Miss America, and then there has to be the first runner-up, because in the event Miss America is unable to fill her duties and obligations, then the next person is right there to jump in, right? We don't want May left without someone to make sure she's safe and someone can make decisions for her. Okay. I love the visual of passing the crown. Okay. We've given you some great resources. Go back to these if you have questions. Frequently, the different circuits also have great information as well. But I've got a ton of information on my website. We've got the PowerPoints we've presented today, as well as all sorts of other good and valuable information. And we're always happy to answer questions if you have them. So I wanted to make sure you had all of this. And that's it. Thank you very much.
Thank you so much, Catherine. That was a wonderful presentation. And I want to remind our attendees that all of our sessions are being recorded, so that you can, again, go back to all this great information and go to those resources that she had mentioned. So we do have a few minutes for some questions. I know that obviously this topic gets a lot of questions. We want to address some of those now. All right. The first question is, do ABLE accounts count as an asset for award?
Yeah, so I'd love to tell you there's a hard and fast rule, but I've had it treated different ways in different circuits. So in my mind, it probably is, right? It should be, right? It belongs to May. It's not mine, it's May's. But I have had circuits where they didn't require an accounting of an ABLE account, and so it didn't trigger the creation of a guardian advocacy of the property. So it depends. The answer for all things is it depends.
That's fine. Another question here is, what are the differences between public and private guardians?
Okay. So imagine there is, so I would be a private guardian, right? I'm May's mom, but just pretend there was somehow no one here to act as guardian advocate for May. So there are public guardians who act for individuals who may have no family members who are able or qualified to act. And they're usually in Central Florida, it's Seniors First, and there's some other groups that do it in other counties, but Seniors First is who does it in Orange County. And they're a public guardian that will then manage many, many wards, not just a single individual, right? So I would likely just be, the only ward I would have would honestly probably be my own child, as opposed to a public guardian who would be paid for and funded, but manage many, many wards.
Right. Great point. Another question here. What happens if you want to be a guardian for an adult outside of Florida?
Okay, so, and we've certainly had that case where there is a guardian. So if the guardian is outside the state of Florida, so just pretend May is here living at Bishop Grady Villas or wherever she's living, and I live in North Carolina, right, where all Floridians retire. I can still be her guardian, right? Because I'm blood related to her. Or it can be we've even had the reverse where the guardian's here and the ward is someplace else if the ward has property here. So there's a process for all things.
So this is another question kind of similar. Can you transfer guardianship from one state to another?
You can, and we've seen that happen many times as well. Florida is not a uniform guardianship state, so it's a little bit of a process, but it's called domestication. And so we will domesticate a foreign guardianship, it could be any other state, and we'll get certain documents out of that court file and then transfer the guardianship here.
Great. Can I file a guardian advocacy before my child turns 18?
The law says that you can file within 6 months before they turn 18. But the joke I always tell is my family is Scottish, and the old saw is that Scottish people are very cheap. So if you file after they turn 18, then they are treated as a household of one for eligibility or indigency purposes. So then you don't have to pay the filing fee and you don't have to pay for the court appointed attorney. So as I always say, from very personal knowledge, having a child with special needs is expensive enough. If I could save $1,000 in filing fees and attorney's fees, I might probably do that. And parents worry a great deal that there would be some sort of emergency that could happen the minute they turn 18. Now, understand the hearing can't happen until after they're 18, but parents get very concerned that if they wait to even file until after May turns 18, that something catastrophic could occur. I've been doing this a long time. If there's a medical emergency, the doctors are still going to take care of her. And I really haven't seen a situation where a catastrophe arose in that very short time. And honestly, even if there were an emergency, we could get to the judges quick enough that they would likely get the orders and letters entered pretty quickly. So don't worry about that one. I always get questions about that.
Can you have co-guardians, and what are the considerations with that?
So you can think mom and dad continuing as guardian for May, but I will tell you some courts and circuits won't allow that. In particular, Volusia County doesn't like co-guardian advocates. Their concern is that they'd be required to act together always, right? Are mom and dad always going to take May to the doctor together? Or mom and dad always going to take May to the bank together? I think that's a reasonable concern. I understand it. I haven't had that situation arise. So, in situations like that, what we've done is had mom or dad be guardian advocate first, and then have whoever wasn't be the standby, right? Mm-hmm. So they're the miscongeniality of the example.
That makes sense.
I'm sorry, the first runner-up. I'm sorry, not the third place. So.
That's great. Well, that is all the time we have for questions. Thank you again, Catherine.
Absolutely.
And for the questions that we did not get to, we'll be working behind the scenes to get those answered to you in the coming days, so have no fear. This concludes our final session of our program. I'll now turn it back to John and Sam for closing remarks and a special announcement.